Hello everyone, it's Anthony Bandiero, attorney for Blue to Gold Law Enforcement Training, bringing you another Roadside Chat on a very, very beautiful fall day. I'm joined with my good friend, Nick. How you doing, Nick?
Doing well, thank you, Anthony.
Now, Nick is a retired officer out of California. He's now in law school, and we actually met a while ago because he was actually sending us some chats, trying to get some clarification on stuff and some feedback. We became friends after that, and he's probably going to be teaching Search and Seizure in the future and so forth, but he loves Search and Seizure.
That's right, I do.
All right, so we had a question about a case called Jones versus the City of North Las Vegas, Nevada. It's a 2025 case. It's kind of a complicated case in my opinion, and I'm not sure how clean it is and how many training points we can gather from it. I think we can get a few, but Nick researched the case. Nick, what's this case about?
Okay, so this case basically is talking about, the premise of the case is hot pursuit.
Okay.
But the background facts of this case is you have some North Las Vegas officers, they respond to a domestic. So they get to the house, the female allows them into the house. They're in the house talking to the female. While they're inside the house talking to the female, they see what looks like, most likely the suspect, fleeing out the back door of the house.
Okay.
They see him go to the backyard, he hops a wall, and he's gone. They did not give chase. Rather, one of the officers runs out the front door, gets in his patrol car, drives around the neighborhood. They
Sounds like a trooper.
So they move right to containment.
Okay.
So during this containment, nearly 20 minutes later, exactly 18 minutes later,
Yep.
you have a K-9 handler that's in the front yard of a house that's about 4 properties east of this house where the domestic took place.
Okay.
The K-9 alerts to the backyard, possibly saying that the suspect could be in the backyard. Mm-hmm. The officer tries to get consent from the homeowner, doesn't get an answer at the door, so he takes his dog, they hop over the wall, go into this backyard, believing that the suspect may be back there. Well, lo and behold, the suspect is not back there, but what's back there is the homeowner's 2 dogs.
Okay.
So the 2 dogs, obviously, are intimidated and threatened by this K-9 officer and his dog. Mm-hmm. The 2 dogs attack his K-9, and the officer shoots and kills both of those, the homeowner's dogs.
So we have a deprivation of property claim. They must have been Yorkies that attacked. They can be kind of vicious. So what's the plaintiff is arguing what? Like what kind of constitutional violation?
So the plaintiff is arguing that, well, under the deprivation, there was no hot pursuit given by the officers. So rather than giving chase right away when the suspect fled the house and went into the backyard, the officers moved to containment. And at that point, you have 18 minutes later when this officer made this intrusion onto curtilage, onto this homeowner's property without consent or without exigency because your hot pursuit is now stale. It's been 18 minutes.
Right.
So that's really the key issue here.
I mean, actually, to be honest with you, 18 minutes is a decent amount of time. That's almost a sitcom without commercials. So, all right, so let's some training points here. Number 1 is, what if the officers gave chase immediately? Would that be a legit hot pursuit, in your opinion?
Under Santana, yeah, it would be.
Okay. They're lawfully present, and they just give chase, right? Now, do you think officers just... let's say that we have a guy that's in front of an apartment complex and we have legit, he runs. And we don't have any Lang versus California problem. We don't have a misdemeanor, a low-level misdemeanor that's no exigency. But he flees into his home, and we'll just even call it a felony, okay, just to make it clean. So he flees into his home, his apartment, and the cops want to wait for another officer to arrive before they actually make that entry so they can have somebody to help them clear the rooms. Do you think that's appropriate?
I do, yeah, I think that's appropriate.
Right.
I think you're still under hot pursuit in a sense. You're also, for sure, in fresh pursuit. Mm-hmm. The courts are going to be more than lenient with you, allowing a reasonable amount of time to wait for the cavalry to take, appropriate safety precautions. Yeah,
and we do have cases on that, by the way. They're several years old, where in fact the California officer, a traffic unit, he was trying to pull over this young kid for traffic violation. He goes home, goes to mommy, goes right into his house, waits for the cavalry. They come. The father will not let the cops in. Mm-hmm. They push their way in. They grab the kid and so forth. Now this is pre-Lang, so maybe not the best facts, but the idea there, or the principle was that the cop did not lose hot pursuit because simply waiting for backup.
Right.
Okay, so I think the first principle is that if you do have hot pursuit and you're going to say it's hot pursuit, you do have to be in hot pursuit. And 18 minutes is a long time. Hot pursuit can absolutely be stale if it's not a continuous chase, right? And I think the last training point is the only part I don't like about this case, and again, I don't have enough details about it, is if the officer reasonably believed, I'm not sure he did, but if the officer reasonably believed that the suspect was in this stranger's backyard, generally speaking, wouldn't that be exigency?
You know, I would think so, but obviously the Ninth Circuit didn't see it that way.
At least it wasn't argued that way. A lot of these cases, again, are argued on a principle of hot pursuit, hot pursuit, hot pursuit. The defendant, right, the defendant's attorney here, the officers, are maybe not really relying on an alternative argument, such as exigency, because they probably don't think they need it. That does happen quite frequently because you are investing, your resources to try to argue that too. Where's the case on that? And maybe the facts are not as great. Maybe the hot pursuit is the better one. Regardless, though, I think that if the officer, and I'm not sure the officer had it here, but if the officer objectively believed independently, besides this hot pursuit, that the suspect was in that backyard, that would be exigency in most cases because the guy is a danger to the homeowner. It could be on the cusp of a home invasion.
Absolutely. The
final thing, though, is the announcement part, right? Maybe that's also part of this, is that the officer was kind of cavalier. Maybe I don't want to have like this. I don't really know what happened, but maybe the officer was cavalier about how he entered that backyard, and maybe the court did not like that either, right?
Yeah, it's possible.
You want to announce, you want to be loud and proud. Hey, police, you don't want that homeowner coming out with the bump in the night with the gun, because we're being sneaky in people's backyards. But we also have a tactical considerations as well. But tactically, we probably want this guy to surrender without getting bit. You have to make, that just as a final point, with K-9s, you have to make an announcement anyway if it's feasible, which would be feasible here. So regardless, maybe that's another factor. I don't know. It probably is not, but I'm just throwing it out there. Guys, I hope you like what we're doing here. We made our best attempt to try to give you some teaching points from this Jones case. If you like what we're doing here at Blue to Gold, like, subscribe, share with your friends. And until next time, you stay safe.